So habeas, mandamus, and T visas. How do all these T visas, and it's also U visas, okay? But habeas, mandamus actually can be I-130s, any petition with USCIS, but we do a lot of T visas. So that's why this is kind of like the final slide and the final thread through this conversation. Habeas and mandamus are two forms of federal litigation. This is a way for us to sue the federal government on behalf of our clients. And to be even more precise, it is our clients suing the federal government, and we're the person who's like doing it for them, right? We've been hired to do this. So if you see the lawsuit, it's going to be the client name versus whoever the attorney general is. Right now it's Pam Bondi, whoever like is the government agent who's in charge. It is a lawsuit where they're saying you have messed up under federal law and I want you to fix it, and I want the district court to do it for me. The reason habeas is so important, and we'll kind of go into the benefit of habeas and the benefit of a mandamus lawsuit. Each of these are two different types of lawsuits in the same federal district court. The reason these are so helpful from a habeas perspective is it helps people who are detained. Or, I mean, like if we have a client, God forbid, is in Guantanamo Bay in Cuba, we need to file a habeas for them. If we have a client who's taken, when we were hearing about all those Iranians who had been taken to this hotel in Panama, people filed a habeas for them. So when you are detained by the government, one of our fundamental rights as anyone who's being detained by the American government is to file a habeas lawsuit. And this is basically saying you're holding me without due process or in some form in violation of the law, and you're not allowed to do that, okay? And then for mandamus, the Latin word is to mandate. And so we're asking the district court to basically, this is my version of going to mom or dad and being like, they're not following the rules. I want you to go in and make them follow the rules for me. A good instance of this is a few years ago, we had a client who he was in removal proceedings and he was about to be deported, but he was eligible for a green card. But the USCIS would not adjudicate his U.S. citizen wife's I-130. And the immigration court kept moving forward with his deportation. Meanwhile, USCIS is just sitting on the I-130 that would keep him here and give him a green card. So we went and sued and we were able to win. And right after that, we got an approval notice. They didn't even respond to our lawsuit. They just sent the approval notice. So these things work. And sometimes they work without any fight. You just have to show up and bark a little bit and you get results. So that's why this should matter to you, because in this day and age, crazy stuff is going on. I think we know that. Crazy, crazy stuff is going on. And so our usual business as usual is not going to work. Now we have to really roll up our sleeves and we have to go over to the federal district court, which is different than an immigration court, and ask them to help us out. And that's what we're going to talk about today, okay? So what's the difference between habeas and mandamus? A habeas is for someone who is detained, faces a risk, like a high risk of detention, or has already been deported, and it was illegal that they were detained to begin with and then that they were deported. Basically, someone took the body, the human body, and did something illegal with it by moving it, by locking them up, and that sort of thing. Or they're about to do something illegally with that human being by putting them into some form of imprisonment, okay? Normally, habeas is used for prisoners, people who are prisoners of war, people who are prisoners here in the United States and are being held without being given a bond, things like that. But in the context of immigration, they're being treated, immigrants who are being detained by the federal government are essentially being treated as prisoners who have they're being held not for committing a crime, but they're being held for immigration purposes. So habeas is when someone is locked up, they're about to be locked up, or they were locked up and then illegally deported. Mandamus, by contrast, is a different procedural vehicle. It's kind of like if I want to get to Guadalajara from Puerto Vallarta, what are all my options of getting there? I can walk, I can take a bus, and let's say I can fly. Or I could drive. Those are my 4 options. Habeas is one option of getting to a result for someone who's detained. Mandamus is another way to the same thing, but usually it's not for someone who's actually been detained or faces detention. Instead, we're saying, hey, judge, USCIS or the federal government in some way is breaking the rules. Mom, dad, the government's being naughty, and we want you to determine that they have been naughty, and we want you to tell them to do it right. And that's usually that's what mandamus is for. The big difference for our client base, sometimes we work with really wealthy people, and the filing fee is not a big concern for them. But the reason I love habeas in particular is it's a $5 filing fee. In this day and age, when filing just an appeal is over $1,000, a $5 filing fee is pretty freaking awesome. And then additionally, mandamus, by contrast, is over $400. Sometimes like 405. It's like $400 basically at a minimum to get your foot in the door in court. And you have to pay that before they will open the case. So sometimes clients are faced with, I got to pay the lawyer and I got to pay this filing fee and I already have this other case pending. I am broke. In situations where they're detained, a $5 habeas filing fee is pretty awesome. Okay. When do you file a habeas? And I'm going to go through each of these as examples. When do you file a habeas? And this is really important for all of us who have clients who are getting detained. So if you're on Team Lauren and one of your clients gets detained, it's really important when you're talking to the family member to ask really specific questions, because otherwise we have to do another intake. So the reason that I have all of you here, paralegals, intake specialists, aka dragons, sales team members for strategy sessions, is because all of us, as soon as we get the call that our client is detained, we need to know what questions to ask. And so I'm going to give you a few scenarios here. And those are this. Let's say client calls, or we have a client and she has an upcoming ICE check-in. Let's say she has a pending T visa. Lauren and I actually worked somewhat on one of these before, and she went to her check-in and didn't get detained, but I don't know how. She was just lucky. But most people are getting detained at their ICE check-ins now, right? So if you know that your client has a way to, if you know that your client has to go into ICE, if you know they're going into the lion's den, we need to think about filing a habeas on their behalf, which would prevent the government from being able to take them into custody. Because it's a habeas in the event that you take them into custody, I'm saying now that it would be illegal. The next option is someone went to their ICE check-in and they were detained. What's really important here is it's not being detained for the first time. Like, if you enter the border, let me tell you what this is not for. If you enter and you're picked up for the very first time and taken to immigration detention, this is not a habeas situation. What I'm talking about is you've already been released. Maybe you were released at the border. You were apprehended, given a notice to appear, and then paroled into the country, or just told, we're going to give you a notice to appear, show up to court. That in this context is having been released. And so if you go to an ICE check-in later and they pick you up, we need to think about habeas. Similarly, if you went and you were in detention and then the immigration judge granted you a bond, and then later on someone is going to pick you up, someone picks you up again, whether it's outside your house, whether it's at your ICE check-in, if they're re-detaining you, they're re-picking you up, this is a great time to consider a habeas. We also have a client who he's been granted withholding of removal and he was detained no notice. This is a great time to file a habeas, because what are you going to do with this guy? You haven't filed a motion to reopen. You can't deport him to a country he's not had a chance to claim a fear from. So you're probably doing something illegal. We need to sue under habeas, okay? When do you file a mandamus by contrast? This is when a client is not detained. If your client's not detained, but USCIS is delaying adjudication, it's a great time. This is like the example where we need this I-130 to be adjudicated so we can move forward with this guy's adjustment of status. But USCIS is sitting on this file for some reason, and it's been 18 months. It's a really good time to consider filing a mandamus. If someone, I had a client a couple years ago who he had entered the country, asked for asylum at JFK airport, and was allowed in. He wasn't given a notice to appear. He then filed for asylum, and 15 years later, he still had not had his asylum interview. Meanwhile, all his family, like his kids and his wife, were still in Africa. So he had spent 15 years away from them because no one had scheduled his interview. This is a great way to file a mandamus, to say you need to get your you-know-what together and schedule this interview because Congress has given you the responsibility of processing these applications and adjudicating them. And 15 years is way beyond reasonable for adjudicating this guy's asylum claim. And he had an amazing asylum claim. When you think about the impact of these delays, what if not only just on the human, 15 years away from your children, that completely sucks. 15 years away from your spouse, do you even know each other anymore? This is awful on the relationship. But when we think about them from an immigration perspective, if they had been granted asylum, let's say 2 years after they got here, they had their interview and got granted, then a couple of years later, they could have filed for adjustment. Meanwhile, they would have been able to bring their family here and they would have been able to file for adjustment. This guy would have been a U.S. citizen long before he's now even had his initial interview. So it's messed up, and this is a way for us to really keep the government on the ball. Mandamus is a really helpful solution when we have USCIS not following established law. Examples are when you make a change under the APA, the government, when it makes big changes, it has to give notice and an opportunity for the public to respond before major changes are made. For example, those of us who have been practicing and doing immigration for a while, you probably remember during the last Trump administration, all the NAs, N/A, that was required in all asylum applications. So if your client didn't have a middle name, you were supposed to put Hillary N.A. Walsh. If you left it blank, because Hillary Walsh has no middle name in this pretend scenario, if you left that space blank, it would get rejected. And you'd have to start all over again. And you wouldn't even really know why it was getting rejected. But then the problem was they were issuing work permits that would say Hillary N.A. Walsh as the name. And Hillary N.A. Walsh is not my name. And then I couldn't go get other documents. So it was this big mess. So what did people do? Well, the Northwest Immigrant Project, awesome attorney who I've learned a ton from, Matt Adams up there, he filed a mandamus lawsuit challenging the use of rejecting USCIS's out of nowhere, rejecting all these asylum applications without ever telling anyone that you need to put in A in these spaces where there's something that's not applicable. They won, and as you all have noticed, we don't have to do that anymore. And that's awesome because it was ridiculous. We as a firm are doing the same thing for this T visa signature nonsense, where they're out of nowhere and only for very select applications like T visas, but they don't require it for an adjustment of status. So it's arbitrary or capricious, which is something you can sue for under mandamus. They're requiring an original signature, and you provide it and all this other stuff, and they haven't announced that the policy changed, and they're applying it unevenly across the board. And so we are suing under the APA in a mandamus for these particular clients. They're not detained. But we want to go in and say, Mom, Dad, the government's not following the rules. They're supposed to give us notice and tell us when something is going to change. Help me out by saying that you can't do this with no notice, and you can't do it unevenly in different parts of filings and forms of relief. So that remains to be seen, but that's a lawsuit we've got going. Okay. Keep in mind, like another lawsuit from Mandamus that is helpful to know about is if we're challenging a part of the law. We have a lawsuit right now. This has been my baby for like years, but the VAWA statute, where if you get a divorce or your spouse dies, you have to file within 2 years. In the Ninth Circuit, there's very specific statutory language that says you can extend that deadline if you can extend that deadline if you have a really good reason. In the law, we call it equitable tolling, but it's basically like an excuse that's very reasonable for why I didn't file within that 2 years. USCIS says, I don't care what your excuse is, 2 years is 2 years. The Ninth Circuit says you can extend it. So I filed for this client. He knew what the deal was. And then I appealed it because I wanted to get an appeal. You have to go all the way up the chain to the extent you can. And then when USCIS on appeal denied it, I took it over to federal district court and filed a mandamus, and we'll see how it goes. Can you blend a mandamus and a habeas? Absolutely. If your client is detained, you can throw the whole kitchen sink in a habeas. Anything you could have put in a mandamus, you can put in a habeas. But if your client's not detained and isn't facing a risk, you cannot file a habeas. So it really does all come down to, are they locking my person up physically or not? Because if not, we need to talk about a mandamus. Okay, let's talk about habeas scenarios, because I'm getting down and dirty and I want to sue big time under habeas because I think it will slow ICE's roll, because then all the federal attorneys are going to be like, you guys have to stop doing this. We're hemorrhaging money and we're going to get sanctioned as an organization, and they have to pay attorney's fees if they lose. And so they're going to be writing our clients checks. And we need to change ICE's policy by attacking their pocketbook. Scenario 1, client is going to an ICE check-in, and we're all worried that they're going to be redetained. We can file a habeas if the client wants to do that as a form of protection. We can also, of course, file a motion for stay of removal, but a motion for stay of removal doesn't help you from getting redetained. It just helps you from getting deported. Habeas could help you from even getting redetained. Number 2, what if we have a client who she was redetained at an ICE check-in, given a bond, paid the bond, released, no new things, going into your ICE check-in like normal for 2 or 3 years, 18 months, whatever you want, redetained with no notice at the ICE check-in. Very, very good habeas option. The client has rearrested the client without notice. This is my most recent habeas that I filed. Client was detained, granted a bond in 2012. Case was administratively closed in 2016. Out of nowhere, no new changes, no criminal history, not even a traffic ticket. Client is leaving for work. ICE picks him up 1 block from his house. Great habeas case. What's the point of having an immigration judge grant a bond if ICE can just show up and redetain you whenever they feel like? It's illegal. Okay, client was redetained at or outside immigration court. And the emphasis on redetained. If they were detained for the very first time, like, I can't really think of a scenario where they would be at immigration court and they hadn't already been released in some way. But let's say that they hadn't been, that they were, they were EWI and got a notice to appear because of a denied adjustment of status, and then they were taken into custody. They're going to have to fight their bond at that point with the immigration court. But if they are redetained, that's a different scenario, and a habeas might be helpful. I want to really hit home on why this is what the basis is for these habeases. Why does redetained matter? Our Constitution promises you due process before life or liberty is infringed upon. Liberty is your freedom to go anywhere. And so the second you're going to detain someone, you have to have due process. What is due process? A full and fair hearing before the government encroaches on your right to liberty. And so what does this mean in basic terms? If the government picks you up again after it's already released you and they don't give you a hearing ahead of time where they prove that your liberty should be limited, you should be locked up, then they have violated the Constitution. And that's what this basis is, okay? That's why it's always about being re-detained. Similarly, you're going to hear about some of these cases where, and we have a colleague who works with us. He was detained on Friday of last week. I filed a habeas for him same day because he's been granted withholding of removal. Why are they detaining him? They have never had a hearing to re-detain him or show that he should be detained again. And then I also have a habeas for someone who she went to an ICE check-in. They arrested her at the ICE check-in, which was illegal, and then they deported her while I had a stay of removal from the Ninth Circuit. So multiple layers. We're going to file a habeas for her, even though she's in Guatemala, and see if we can get her brought back, because she never would have been deported had they not acted illegally to begin with. Here's how T visas and U visas connect to all of this. If you have a client, especially for T visas, it's really challenging, right? Because if our client with a T visa is removed, they lose their T visa, their eligibility, because it's required that you're here in the United States in order to be eligible for a T visa. So if our client gets detained or we think they're about to get detained, we need to file a habeas or a mandamus, depending on like how we want to get there. Do we want to take the bus to Guadalajara, or do we want to fly, or do we want to walk? We know we need to get to Guadalajara, which is we know we need to get into federal district court. And we need to demand that USCIS adjudicate either the T visa or U visa, or better yet, make a decision on the bona fide determination. And we can force them to do that if it's been filed for 90 days. If it's been filed for 90 days. And this again is why we want to get our cases filed, even if we don't have the receipt notice showing when it was filed, because right now it's taking so long to get receipt notices. The responsibility on USCIS isn't from the date that it's receipted. It's from the date it was received. 90 days from filing is when you are owed a bona fide determination. And a bona fide determination gets you a stay of removal for a T visa or for a U visa. So if we need to, we're going to go in and sue for this to prevent our client from getting deported potentially, and obviously potentially losing their form of relief like a T visa. That is all the time we have right now. I've got like a couple of minutes, but if you want to learn, I do really quick videos on this on TikTok. I'm not looking for followers. This is not like a pitch to like come follow me or whatever. I am looking to educate people. And so if this is the sort of thing that you want to be, if you're on our team, you really should follow this, because this is my way of being able to train you in 15 seconds to a minute is what most of my videos are. And it gives you, thank you. The QR code was generated by our awesome, who also made all my slides really fast for me, by awesome Ariadna. But this is where I talk about this stuff. That way, when clients are calling in, you know why they're calling and what they're saying, because they just heard about this on TikTok and now they're calling in. If you're slow to this, then you're going to kind of be left behind. And the same is true for our legal team, where if we have new options available, we have to always consume those so that we can help our clients to the best of our ability.